Hello, everyone, and welcome back. Before we continue on, I would like to remind you that I am not a labor lawyer and I am not certified to practice law in Vietnam. I'm just simply a guy from the United States who knows about the Vietnamese labor code. Now, today, excuse me about that. I just burped. Excuse me again. All right. Now, today I got a very good special for you. We're going to be talking about how to quit your job legally here in Vietnam without getting a lawsuit. I know, big deal. So, first things first, we're going to go ahead and show you this. This is one of the biggest things ever that a lot of English centers like to do. They like to say, oh, well, you're just a part-time worker. You're just a part-time worker. Okay, let's go over that. So, Article 32, part-time employment. A part-time employee is an employee who works for less than the usual daily, weekly, or monthly working hours as prescribed by labor laws, the collective bargaining agreement, or internal labor regulations. Clause 1. So that defines what a part-time employee is. Normally, English teachers are defined as part-time employees because they only work about, 15, 18, 20, 25 hours a week. They don't work that much when compared to the full 40, 48 hours a week that industrial workers normally work. So that's what that is. Clause 1, Clause 1. Moving on. Clause 2. An employee may negotiate part-time employment with the employer when entering into an employment contract. Remember, this was typed from Vietnamese into English. That's the reason why you keep seeing mess-ups like that. Moving on. Entering. Might as well change that while I'm here. All right. Again, I'm going to tell you guys that the Vietnamese version is the only one that matters. The one in English is just for reference. So, moving on. Clause 3. This is the big one right here. Whenever they tell you that you're a part-time employee and blah, 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 that's just a buzzword. Clause 3. The part-time employee shall be entitled to receive salary, equal rights and obligations as a full-time employee, equal opportunity and treatment, and to a safe and hygienic working environment. Now, why is this important? Remember, even though you're classified as a part-time employee under Article 5 and under Article 6, I think maybe just Article 5, that you are entitled to a safe and hygienic working environment. Even a part-time worker, same thing, entitled to a safe and hygienic working environment as well as the equal opportunity and treatment. So if they want to try and tell you that essentially you don't matter because you're a part-time worker, well, the law tells them that they are wrong. So just remember that. You are entitled to everything a full-time employee is entitled to. Article 32, Clause 3. Part-time employment, Clause 3. Article 32, Clause 3. So, moving on. Termination of employment contracts. Now, the reason why I mentioned that all beforehand is that you know that, yes, you are a part-time employee, but you matter and you do have rights. That's why I mentioned that. So, again, Section 3, Article 34, Article 34. Cases of termination of an employment contract. Now, I really want everyone to pay attention because I don't want to waste calories and breath repeating myself, even though I do that anyways from time to time. Clause 1. The employment contract expires except for the case specified in Clause 4, Article 177 of this code. We may or may not actually touch on that. We'll figure that out later. Clause 2. Essentially, this means that when the contract expires and the employer does not want to give you a new contract, then yeah, that's that. Now, Clause 2. The tasks stated in the employment contract have been completed, like for contract or piecework. Clause 3. Both parties agree to terminate the employment contract. So both parties agree to terminate the employment contract. But that's only if both parties agree. Both parties agree. Clause 4. What happens when you go ahead and party too hard? Well, this. Clause 4. The employee is sentenced to imprisonment without being eligible for suspension or release as prescribed in Clause 5, Article 328 of the Criminal Procedural Code, capital punishment, or is prohibited from performing the work stated in the employment contract by an effective verdict or judgment of the court. So, yeah, if you screw up and you go to prison, then, yeah, you can have your contract terminated. Clause 5. And this applies directly to foreign workers because it says so. Clause 5. The foreign employee working in Vietnam is expelled by an effective verdict or judgment of the court or a decision of a competent authority. So, essentially, if you're a foreign worker, you come to Vietnam, you mess up too many times, they do have the right to not only kick you out of the country, but also go ahead and terminate your contract too. Now, the employee dies. is declared by the court as a legally incapacitated person, missing or dead. So, yeah, if you pass away, then, yeah, they can terminate your contract, obviously. Now, the employer, what we talked about earlier, the employer that is a natural person dies, is declared by the court as a legally incapacitated person, missing or dead. The employer that is not a natural person ceases to operate, or a business registration authority affiliated to the People's Committee of the province, hereinafter referred to as Provincial Business Registration Authority, issues a notice that the employer does not have a legal representative or a person authorized to exercise the legal representative's rights and obligations. Oh, that was a big breath. All right, let's move on. Clause 8. The employee is dismissed for disciplinary reasons. And yes, we will get to that too. Trust me. I will teach you about how employers are supposed to properly discipline their employees. We have about 19 minutes left. We're actually on good time today. All right, cool. So, clause 9. The employee unilaterally terminates the employment contract in accordance with Article 35 of this code. That's what we're going to talk about. Now, there's the right way and a wrong way to do that. We'll get to that later. Number 10, the employer unilaterally terminates the employment contract in accordance with Article 36 of this code. Clause 11, the employer allows the employee to resign in accordance with Article 42 and Article 43 of this code. Clause 12, the work permit or a foreign employee expires according to Article 156 of this labor code. And again, we already talked about 156. I think we did anyways. There was a 154 clause 8 and then Article 155. So no, we didn't talk about 156, but that's okay. Clause 13, the employee fails to perform his or her task during the probationary period under the employment contract or gives up the probation. So yeah, if they don't do their work on probation, then yeah, they can have their contract terminated right there. Now, a lot of this I may have to go to supporting articles and clauses to go ahead and explain this properly. But yeah, so this is the big one. The right of an employee to unilaterally terminate the employment contract. Remember, under Article 151 Clause 3, foreigners are protected by the Labor Code of Vietnam. And you are allowed to unilaterally terminate your employment contract in certain circumstances. And that's what we're going over right now. Article 35, the right of an employee to unilaterally terminate the employment contract. Clause 1. An employee shall have the right to unilaterally terminate the employment contract, provided he or she notifies the employer in advance at least 45 days in case of an indefinite term employment contract. Now, it's actually very rare for a foreigner to have an indefinite day or an indefinite term contract. But the employee, if you want to quit and you have an indefinite term contract, you must notify your employer at least 45 days in advance. Now, in my opinion, you should do this in writing, because the employer is supposed to give you notice in writing when they terminate your contract, and we'll get to that later. At least 30 days in cases of an employment contract with a fixed term of 12 to 36 months. This is what's standard for English teachers. Normally, an English teacher's contract is about, 12 to 24 months, thereabouts. So in that case, you want to give at least 30 days notice if your contract is between 12 to 36 months. But remember, if you are a public school teacher only and your contract is for 1 year, but they only have you work 9 months out of the year, in my opinion, they're still responsible for the other 3. They're supposed to give you work. If they don't, they're supposed to pay you the minimum wage per month. At least in my opinion, they're supposed to do that. They shouldn't give you a year-long contract and only let you work 9 months, and then the other 3 you have to hang out and do nothing. That's not right. Now, here's a good one. Subclause C, at least 3 working days in cases of an employment contract with a fixed term of under 12 months, which my most recent English center, I signed a contract last year that was specified as from the time I signed until the end of the school year. That's obviously less than 1 year, or that's obviously less than 1 year. Therefore, only 3 working days is needed. That's it. Now, letter D. Moving it on up, letter D. The notice period in certain fields and jobs shall be specified by the government. Now, I'm thinking that refers to stuff like, industrial workers, military, police, and so on and so forth. Moving on, Clause 2. This is the big one. So if you haven't been paying attention this entire video, you should pay attention now. This is literally the creme de la creme of what I have to offer you today. Clause 2. An employee shall have the right to unilaterally terminate the employment contract without prior notice. Pay attention, people. Without prior notice, if he or she, subclause A, is not assigned to the work or workplace or not provided with the working conditions as agreed in the employment contract, except for the cases specified in Article 29 of this labor code. And that's reassignment against the employment contract, and we'll talk about all that stuff later. That's a separate part about talking about the employment contract itself. So moving on. This means that if you're not given your job, you're not provided with your working conditions or anything like that, like you sign a contract to become an English teacher, yet they don't give you an English teacher job. They don't let you work. That's what that means. Now, subclause B. Again, I'm looking at you, Apex, and yeah, I'm calling you out. Is not paid adequately or on schedule, except for the case specified in Clause 4, Article 97 of this code, which I'm pretty sure we mentioned that about the force majeure clause and stuff like that. Now, here's a big one. Okay, so there's B. And this does apply to English teachers because this happens a lot to English teachers, but a lot of people don't know about this. Subclause C is maltreated, assaulted, physically or verbally insulted by the employer in a manner that affects the employee's health, dignity, or honor, is forced to work against his or her will. This is the big one right here. Reason why is simple. Many English teachers in Vietnam are maltreated all the time because a lot of English teachers go teach in public schools. Now, yes, I'm not saying that all public schools are bad. No. But the vast majority are. Every single one I've taught at, there's only been 1 or 2 classes that I can actually remember out of the whole 4 years I taught that were actually good classes. All the rest of them were varying shades of disappointment because it is said here in Vietnam that it is not the parents that raise their kids, it's the teachers that do. The problem is the fact that when I have to come into a public school and have to teach a classroom of 50 students with a TA that doesn't want to or doesn't know how to do her job and can't communicate with me, that adds a lot of stress, and stress is a form of maltreatment. Assaulted. Now, I physically have never been assaulted by students, but I've been verbally assaulted by students. I've been called names and things like that. Physically or verbally insulted, same thing. Insult is an assault. At least that's what I consider it as. But assaulted, they mean physically. So physically or verbally insulted, but that was by students. Now, the employer, if you're physically or verbally insulted by the employer, that means, like, I actually have physical proof of this, of an employer calling me stupid. Yeah, I actually have physical proof of that. And if you're paying attention, you know who you are. Now, insulted in the manner that affects the employee's health, dignity, or honor. Health, dignity, or honor. So if your employer insults you and it affects your dignity or your honor, that's illegal. You can quit on the spot. Is forced to work against his or her will. Now, that is more about human trafficking and stuff like that, but how it could work for English teachers is there's another article I'm going to talk about, Article 17, and one of those forbidden rules is the fact that essentially it's forbidden for the employer to keep your important documents. That's one of the tactics that a lot of evil English centers like to do. They like to keep important documents like your passport and stuff like that to make you work more. They are not allowed to do that, and not only that, you are allowed to quit immediately if you are being forced to work against your will. If you are sexually harassed in the workplace, this is the big one. Again, right here. And also, I'm going to go ahead and say that sexual harassment can happen to men as well as women. If you do not agree, you need to go back and review a few things. That's all I'm going to say. Sexual harassment can happen to men as well as women. Now, something that specifically applies to women. If you are pregnant and you have to stop working in accordance with Clause 1, Article 138 of this labor code, we already discussed that, under the gender equality laws. Moving on, reaches the retirement age specified in Article 169 of this labor code, unless otherwise agreed by the parties, or Clause G, one of the big ones, finds that the employer fails to provide truthful information in accordance with Clause 1, Article 16 of this labor code in a manner that affects the performance of the employment contract. Now, what does this mean? This means that if your employer lied to you about working, like say they said you're going to work in one place, but then you end up working in a different place and it's a complete slag heap, you know, you don't want to work there at all. So, yeah, you can quit if you find out that your employer lied to you about where you're working and stuff like that. So we're going to talk about these other articles, Article 16, Article 17, stuff like that later on. We have about 10 minutes left, so we're actually going to go ahead and talk about Article 36 too. This is the flip side, how your employer can fire you. So we're going to go ahead and get through this. And then, yeah, we're also going to talk about how to properly discipline employees and stuff like that later on. So again, Article 36, Article 36. Let's get started. Clause 1. An employer shall have the right to unilaterally terminate an employment contract in one of the following circumstances. Again, English, Vietnamese. The employee repeatedly fails to perform his or her work according to the criteria for assessment of employees' fulfillment of duties established by the employer. So essentially, if the employee refuses to work, the employer can fire them. The criteria for assessment of employees' fulfillment of duties shall be established by the employer with consideration taken of opinions offered by the representative organizations of employees, if any. So essentially, yeah, if you don't do your job, you can get fired. And how they rate that is by talking to, different organizations, if any, or the employer. Moving on. We got about like 8 minutes left, so I'm going to try and get through this. All right, so the clause B, subclause B, the employee is sick or has an accident and remains unable to work after having received treatment for a period of 12 consecutive months. So if you're out for 1 year and you can't come back to work, you're done. Now, and that's if in a case of an indefinite term contract for 6 months consecutive back-to-back in the case of an employment contract with a fixed term of 12 to 36 months, or more than half the duration of the contract in case of an employment contract with a fixed term of less than 12 months. All right. Now, what that means is simple. If you have an indefinite term contract and you can't work over a year, you get fired. If you have a term between 12 and 36 months and you can't work for more than 6 consecutive months, you get fired. If you have a contract under 12 months, then half of your contract should be how much time you can be out, and that's it. Upon recovery, the employer may consider concluding another employment contract with the employee. Upon recovery. Now, letter C. Here we go. Letter C. In the event of a natural disaster, fire, major epidemic like COVID-19, hostility, relocation, or downsizing requested by a competent authority, the employer has to lay off employees after all possibilities have been exhausted. Now, this one is a bit contested because of the fact that if the company is beleaguered to the point where they can't go ahead and have employees anymore, then yeah, they have to downsize. That's just the way it is. But remember, after all possibilities have been exhausted. So if they're trying to be greedy and they want to go ahead and fire you to save some money, that's not cool. If they can still hire you, they can still pay you, they should. Now, letter D. The employee is not present at the workplace after the time limit specified in Article 31 of this labor code. Now, Article 31, if I remember rightly, goes ahead and says 15 days. You have 15 days to be at the workplace. If you're not there in 15 days, then you can get fired. Double D, which in Vietnamese is a D with a slash through it, right here. Double D, the employee reaches the age of retirement specified in Article 169 of this labor code unless otherwise agreed by the parties. Right there. The employee quits. Subclause E. The employee quits his or her job and fails to go to work without an acceptable excuses for at least 5 consecutive working days. Letter E, right there. That means 5 back-to-back days. Letter G. The employee fails to provide truthful information during the conclusion of the employment contract in accordance with Clause 2, Article 16 of this labor code in a manner that affects the recruitment. So if the employee lied and say things like they're a native speaker when they're really not, and they don't want to go ahead and provide documentation that proves they're a native speaker, then yeah, the employer can go ahead and fire them for that. And the reason why I bring that up is because there's a lot of non-native speakers that like to claim they're native speakers so they can claim that higher salary. Moving on. So, Clause 2. When unilaterally terminating the employment contract in any of the cases specified in point A, B, C, double D, and G, Clause 1 of this article, the employer shall inform the employer shall inform the employee in advance. The employer shall notify or inform the employee in advance. This means they must tell you. They can't just, oh, you're done. Subclause A, at least 45 days in the case of an indefinite term employment contract. Subclause B, at least 30 days in case of an employment contract with a fixed term of 12 to 36 months. So if you're an employer and you want to fire someone with a contract of 12 to 36 months and you can do it legally, you must give them at least 30 days notice. There is no excuse. And then subclause C, which is down here, at least 3 working days of an employment contract with a fixed term of less than 12 months, and in the cases stipulated of point B, clause 1 of this article. Please hold on 1 second. I need to take a drink of water. All right, cool. Let's keep going. So, subclause D, the notice period in certain fields and jobs shall be specified by the government. All right, so D and D. All right, now, clause 3. When unilaterally terminating the employment contract in the cases mentioned in point D and point E, clause 1 of this article, the employer is not required to inform the employee in advance. So we got about 4 minutes left, so let's go ahead and look at all these little subclauses and stuff real quick. All right, so clause 3 mentions point D and point E, clause 1. Point D and point E, clause 1. Point D or point E. The employee is not present at the workplace after 15 days, according to Article 31. Subclause E, the employee quits his or her job and fails to go to work without acceptable excuse for at least 5 consecutive working days. Point D and point E, clause 1, they are not required to notify you in advance. So, yeah. Now, for cases A, B, C, double D, and G, A, B, C, double D, and G, they are required to tell you. Again, 45 days with an indefinite term contract, 30 days with a contract of 12 to 36 months, and at least 3 working days of an employment contract of a fixed term of less than 12 months. And they are required to do this. Now, another article will say that they are required to give you this notice in writing. If they don't give it to you in writing, that means it is no good. So, we got about 2 minutes left. Let's see what else we can go ahead and get through here. Let's see. Oh, here we go. Article 37. We could talk about this one real quick. Article 37. Cases in which an employer is prohibited from unilaterally terminating the employment contract. Pay attention. This is a big one. The employee is suffering from an illness or work accident, occupational disease, and is being treated or nursed under the decision of a competent health institution, except for the cases stipulated in point B, clause 1, article 36 of this labor code. Clause 2. The employee is on annual leave, personal leave, or any other types of leave permitted by the employer. So if you're on leave, you're doing your thing, your employer can't fire you. Clause 3. The employee is pregnant, on maternal leave, or raising a child under 12 months of age. Now, this one specifically does not mention male or female. It just says on maternal leave or raising a child under 12 months of age. They are forbidden from unilaterally terminating your employment contract, either through notice or, without notice. They can't terminate your contract, period. Now, we have less than a minute left. Article 38 states that either party may withdraw the unilateral termination of an employment contract at any time prior to the expiry of the notice period by a written notification, provided that the withdrawal is agreed by the other party. So if you want to come back to work, it's got to be agreed to by both parties. Article 39, illegal unilateral termination of employment contracts. This is another big one you need to pay attention to. The unilateral termination of an employment contract will be illegal if it does not comply with regulations of Articles 35, 36, and 37 of this labor code, of which we just covered. Now, we have less than a minute left before we go ahead and go to the 5-minute warm down before I go ahead and put this video on YouTube. So we're just going to go ahead and say this. Today, I went ahead and taught you about the labor code, about how to properly quit your job. Now, I want you to remember everything I've said so that if they say you must do this, you must do that, well, if you want to quit your job, like I said, normal 12, 36 months, you must go ahead and give a 30-day notice. And please, write it down on paper, or if your handwriting is bad like mine, go ahead and type it up and sign it and give a copy to them so that they know what's going on. And if they try to say that they didn't get a copy, well, make sure that they sign it too. You have 2 copies, one for them, one for you. They sign, you sign. This way you can say that, yes, you got a copy of this and it's 30 days. One other thing I'm supposed to say is the fact that the other part I'm going to talk about in the next video I'm going to talk about is the fact that they are required to pay you. Say, for instance, you gave them your 30 days notice, but then say 15 days into it, they're like, okay, we don't need you anymore. We already got somebody else. Well, they are required by law to pay you the rest of the 30 days. So you give a 30-day notice, they received it, they make you leave halfway through, they're required to pay you for the other 15 days. Provided you work, the 15 days, whatever days you work. So, all right, now we're going to go ahead and get to the end of this video. The next video, we're going to talk more about this. So, this is the end of the video. It's already at 40 minutes. And you can see the counter counting down. So, if you like this video, please, like, share, subscribe, comment on my videos. If you want to go ahead and donate to me, I do have an international bank account that accepts currency from all over the world, but there will be a conversion rate on that. If you're in Vietnam, the minimum amount to tip me is 10,000 dong because that's what the apps allow for. However, you can send me as much as you want. I need a lot of cash right now, and it's not so much for me, but it's for my family because I need to go ahead and buy stuff for my daughter. I need to give my parents money for rent, stuff like that. I really need to take care of my family. That's what the money's going to be going for right now. So if you want to donate goods like, electronics and stuff like that, please make sure it is unused, unopened. Unused, unopened. For food, I request that it be non-perishable and unopened so that this way it's, food and health standards and hygiene and whatnot else. Now, I hope that you go ahead and tell everyone about these videos that I'm putting out because I want everyone to know their rights from Phu Quoc Island all the way to Sapa. I want all foreigners, I want all locals that can understand English to go ahead and even those who can't understand English. I'm just going to say everybody. I want everybody to know their rights under the laws. So I'm going to go ahead and say, have a good day, be safe, and see you in the next videos.